In order to get CLE credits, you have to listen for the secret word. It will be repeated twice during the video presentation. And sometime during the original presentation, Karen CORSI gave a secret code, and she announced it and may have even held up a sign. And you need that code as well. So there's two codes: the secret word, which is audio only, repeated twice, and the one where Karen CORSI said it on the day of the presentation. Jot them down as you listen. You obviously have to pay attention. Good luck. Good afternoon, everybody. I suspect you guys, if you've been to a couple of these programs in the past few weeks, remember me. My name's Joe Del Russo. I'm the education coordinator for the Passaic County Bar Association. And this is our last program for the year. This is a good time to get your credits because the year is quickly dissipating. And these credits are pretty important. These are what we call DIE credits, diversity, inclusion, and the elimination of bias. May have heard it called DEI also, but whatever it is, these credits certainly will allow you to comply with the 2 credits of the 5 ethics credits that you're required to have in your reporting period. So we're excited about that. And we're excited to have everybody here today to learn about these issues, these very important issues. Now, our presenter today is a colleague of mine that I know for many, many years. And I'll tell you real quickly, the first time I laid eyes on her, I was a young chief assistant prosecutor in the Passaic County Prosecutor's Child Abuse Unit. And Sue is only a year or 2 older than me, but when I went down to Trenton to my first meeting for the governor's task force on abuse and neglect, Sue was the chair of that group. And I was very impressed, almost smitten. And I said, that's what I want to do one day. I never achieved that, but I got to know all the people there. And I certainly got involved in my own initiatives around the state when it comes to protecting children and prosecuting crimes on children and child maltreatment. But I admired her not only because she's eloquent, she's a brilliant lawyer, but I also admired her because, you know, these kind of things impressed me back then. She was up and down to the appellate division. She not only had cases that she tried at the trial level, she also had cases that made law in the appellate division. And one of them was called State versus Donegan. And while the landscape has changed, Donegan really set the table for permitting the videotaped statements of children to be admissible in court as an exception to the hearsay rule, essentially consistent with Idaho versus Wright, which is a Supreme Court case of the United States. And I was like, wow, that's pretty cool. And I became involved in the movement to make sure that law and that evidence rule continued in the state of New Jersey. And in fact, I had to testify a couple of times before the Senate Judiciary Committee to prevent the legislature from abandoning the right of children to be heard in a non-hostile environment on a video recording by an expert forensic interviewer. So anyway, Sue is now retired from the prosecutor's office in Atlantic County, where she was a chief for many years, as am I, retired from Passaic County Prosecutor's Office. She went to Widener School of Law, got her JD cum laude, went to Rutgers, got a bachelor's degree in history, admitted to the bar, certified by the Supreme Court, certified by the Police Training Commission. She is of counsel right now at Helmer, Conley, and Castleman. She also had her own law office for a while from 2004 to 2018. She's an adjunct professor at Montclair State University, where I continue to teach. She was an assistant professor for some time there as well on a tenure track, and then went back into practice in law. When there's a homicide or an armed robbery or gang involvement shootings, Sue defends them because she never really went into adult defense like I did. Her focus has always been on children. And this program, despite the fact that some of these young people did some really bad things, she believes in redemption. She believes that children have a right to a second chance. And she's going to talk to you about that process today. Sue?
Joe, thank you very much. That was very nice. I am, however, doing pool work for them, and I do it on very serious cases. So most of my attention today is going to be directed toward the serious case. Just by way of preliminary remarks, I want to point out to you that this presentation is close to 2 hours. It's an hour and, Joe, what is it, an hour and 40 minutes?
Right.
And I think that one person talking for an hour and 40 minutes gets to be drone-like and relatively boring. So what I would like to do is effectively stimulate conversation. I would like for those of you who are involved in actually representing children in the courts to tell me what's happening in your counties, or challenge some of the things I say if you think things I say are appropriate for challenge, and we'll have a discussion about it. I think that's a better way to fill our time. And in the meantime, I'll make sure that we're covering everything we need to cover for your credits. So on that note, can I ask for, well, what I'll do is I will open up my presentation, share my screen, and then we can talk. Okay? Anything else, Joe, that you want to go over before we begin?
No, we're good. Just share the screen and we're good to go.
How's that?
Perfect.
Okay, good. Now, I'm sorry, I'm having a little bit of a throat issue here. If that causes anybody any difficulty, let me know. So as you can see, I made a title out of this: DEI and other important considerations in juvenile delinquency practice. But as Joe said earlier, the Supreme Court looks at this a little differently. DEI stands for diversity, equity, and inclusion. And that was the original terminology. Some folks have modernized it to DEIB, which is diversity, equity, inclusion, and belonging. And the New Jersey Supreme Court has changed it to diversity, inclusion, and equity and elimination of bias. Is that correct, Joe?
Diversity, inclusion, and elimination of bias. DI.
Right. Okay. Yes, as opposed to DEI.
Yeah.
But it's all essentially the same thing. What we're talking about is a certain population being treated differently because of their gender, ethnicity, disability, or other things about themselves that are not within their control to necessarily change. So one of the things that you will repetitively see in DEI considerations is the concept of disabilities. And what I want to specifically talk to you about today, because there's a population of people with disabilities who sometimes suffer implicit or systemic biases because of their disabilities. What I want to address with you today are specifically children, youth in our juvenile delinquency system who are experiencing systemic biases that are implicit biases. That means not biases that are by design or intent, but occur naturally through a system that we've learned to work within. And they're difficult sometimes to expose, and they're difficult sometimes to change because there's not generally intentionality that relates to these kinds of implicit biases. But my contention is, and I hope to support that for you with enough data so that you can make your case in a courtroom, that youth with educational disabilities experience some implicit bias, systemic bias within the juvenile delinquency system. And then, well, let me go to the next slide. In the next slide, I want to discuss with you our goals for this discussion today. Oops, move this over. Okay. The first focus of my discussion today is going to be on the DEI topic, youth with learning disabilities, and the impact on them becoming engaged in the juvenile justice system and being treated in the juvenile justice system. Now, I'm doing this because I hope to get to the point where you're getting enough data here so that if you have a child who has learning disabilities, you are going to be able to make your case in the juvenile court that those disabilities have to be acknowledged and worked with in the processing and sentencing of this youth. And I will provide data. I know that may be a little bit boring, but the idea here is that you will have a go-to source of information that where you can find citations and you can find the information you need to share with the court when it is necessary. The second aspect of this, or focus of this discussion I want to have with you, is going to be the practical suggestions on how you can address the disabilities issue in your particular client's case. In the court system, convincing a judge that a particular youth, because of his disability, should be treated in particular ways or assigned to particular programs may be difficult, because judges are human, and there are many who believe that, many people believe that if you're old enough to do a crime, you're old enough to, some people will say, do the time. And while the juvenile system is supposed to be focused upon rehabilitation, when you have serious crimes being committed by the youth we represent, it is very difficult to invoke some level of sympathy or understanding for this wrongdoer. And it is very difficult to link the conduct of the wrongdoer to a disability. There are lots of kids with disabilities who don't act out criminally. So the idea that the disability may be correlated with the criminal behavior and may be something the judge needs to take into consideration, not only in deciding the case, if the case is being decided in the juvenile court, but in processing it through by way of sentencing, reference to programs, and issues of that type. So I want to give you some of the things you need to convince your judge. Now, one of those things is to refer to the New Jersey Supreme Court. The New Jersey Supreme Court has just presented its fifth installment of action plans for ensuring equal justice. That's what they call it. And you can find that at the Supreme Court's website. The court has made a public statement for 2024 on its action plan to eliminate injustice. And one of the things the court specifically says in that report is that, so the New Jersey Supreme Court promises, it's renewing its promise to deliver equitable justice, in particular people who have faced barriers because of their race, ethnicity, gender, sexual orientation, disability, and other aspects of identity. So disability has been very specifically included by the New Jersey Supreme Court as one of the issues that requires a judge to attend to the need for equal justice, equitable justice. The second focus that I want this talk to deal with is practical suggestions on how you're getting the judge to address the learning disability issue in your client's case. Now, most of the time that's going to come at sentencing. So I'm going to be discussing with you both plea bargaining issues and then sentencing arguments that allow you to talk in terms of how the learning disability relates to your aggravating and mitigating factors. And then finally, my third focus is going to be on a few new developments in the juvenile justice process in New Jersey. There's been some recent legislation that I think indicates new and harkens to the potential for more problems and hardening of the system as it relates to serious acts of delinquency for youth who are 15 to 18. Now, I deal mostly with waiver cases, as you heard from Joe, serious delinquency. So I probably won't be helping you very much if in your own juvenile practice, what you're dealing with is clients who are coming in with private pay from their parents because they've been involved in shoplifting or car burglaries. Those cases are going to tend to resolve either if they have no records with informal presentations through the court or with probation sentences off the formal calendar. So you're probably not going to get a lot of practical thoughts about how to deal with those kids. I'm talking about the clients who are engaging in serious delinquent conduct, many of which are being violent, many of which are involved with weaponry. Okay, so that's where I'm planning to go. And now we're going to go there. First of all, any conversation that begins with education and educational disabilities has to begin in New Jersey with the New Jersey Constitution. The New Jersey Constitution requires that every child have a thorough and efficient education. It's called the T&E clause, and New Jersey's T&E clause, thorough and efficient education clause, was the basis for a series of cases called Abbott versus Board of Education some years ago that probably many of you will remember that. What that actually was about funding school systems, the state funding school systems. It went on for over 25 years. There was case after case. They actually had an Abbott 24. The funding problem, as far as I know, is still an issue. But the basis of the funding discussion was whether the state was going to be funding certain districts who had children who had special needs. And that's why with learning disabilities, this is where we have to begin, because the learning disabled children are the children who have special needs. Now, there's a body of implementing legislation. There's a body of implementing legislation in New Jersey for the thorough and efficient education. But there's also, it's coordinated with federal law. The federal law that we deal with now that relates to children with learning disabilities is called Individuals with Disabilities Education Act. This law was originally enacted under the name, I'm sorry, this was the name that it was under a different name, but it was reauthorized in 2004, and it's continued to be reauthorized under this new name, and it's continued to be reauthorized. So at this point, if you have a child with learning disabilities, that child is covered by the IDEA. Now, the IDEA requires that all children with disabilities receive free, appropriate public education. Free, appropriate public education. That is New Jersey's, the equivalent of New Jersey's thorough and efficient education, essentially. Now, an attorney who deals with education law may challenge me on that, but it is certain. And there's, I'll tell you about an article that says exactly this shortly. Through the juvenile delinquency system, you are going to be able to eliminate a child's freedom as a sentencing provision, but you cannot take away the right of FAPE, that free, appropriate education for children under the age of 18. So if you have a child for whom you are trying to advocate because, or including issues that relate to a learning disability, this is important for you to be able to present to the court. Court needs to understand that that child, even if he is directed to a correctional facility, even if he is detained for an extended period of time, even for a short period of time, that child is entitled to a free, appropriate public education, thorough and efficient in New Jersey. And for youth who are disabled, that will mean that they're getting the type of education that is called for in their IEP, which is the Individual Education Plan. Okay, everybody good with that? The idea, the Federal Act extends, make sure that students in correctional facilities are covered by this law, and the responsibility is supposed to be from the local education agency. So there's supposed to be linkages between your local education agency and the correctional facilities. But if you have a youth in New Jersey, if you have a youth who is sent to Jamesburg, the training school for boys, or otherwise is in the custody of the juvenile commission, that youth will get evaluated for special education. He will get, and that includes all of the evaluations they do, including your psychological evaluation. And that psychological evaluation will be very important. We're going to talk about that again in a few minutes. There's a Juvenile Justice and Delinquency Prevention Act that was originally passed in 1974, and it had core requirements. This again is a federal act. It had core requirements addressing racial and ethnic disparities. That was one of them. There were more than that, of course. There were 4 of them, but one of the 4 was addressing racial and ethnic disparities. That is most recently reenacted in 2018. It continues in effect, obviously. And what it does is provide funding. What it does is provide funding to the states for the elimination of the problems with the core requirement. Let me go back to that. For the core requirements to be met. So there's guidelines for the state on how to meet core requirements, including addressing racial and ethnic disparities. And then the states that are complying are funded through this act. So again, you're in a position to stress for the judge the need for racial and ethnic disparities to be addressed in the court, in her court or his court. Now, I've been talking about learning disabilities. Disabilities has new language, modern language. We're talking about neurodiversity now, so that if you're doing research, you're not going to just do research on learning disabilities. You're going to look at neurodiversity. Neurodiversity includes learning disabilities. It is, and those particular disabilities would be ADHD and autism as examples. But what neurodiversity actually does is describe the idea that people experience the world differently. We're not really talking about them as being disabled. We're talking about people having diverse methods and experiences in dealing with the world and interacting with the world. So it's there's no particular right way, in other words, for a person to interact with the world. The modern thought is that differences are not viewed as deficits. So we're not really talking, again, in terms of disabilities so much as we are neurodiversity. Now, with regard to learning disabilities as neurodiversity, there are 8 academic domains. 8 academic domains, okay, where children may have issues in learning. Those include, and I'm just going to read them real fast, all 8 of them: oral expression, listening comprehension, written expression, basic reading skills, reading fluency skills, reading comprehension, mathematic calculation, math problem solving. That's 8. Now, if you listen closely to what I was just talking about, oral expression, think about your clients. If you're dealing with clients who are engaged in serious juvenile delinquency, serious criminality that is being prosecuted in the juvenile court, especially those who are involved with guns, violence, and are looking at potential waiver cases. Let's talk about their oral expression abilities, their oral expression skills. Think about it. Next, listening comprehension. Next, written expression. Basic reading skills, reading fluency, and reading comprehension. So, of the 8, I just read you the first 6, most of which deal with reading, the ability to understand the reading, and the ability to communicate. Now, for my clients, the youth really don't read well in a large percentage of the cases. Now, if you have a client with you, don't just ask him, can you read and write the English language? That's one of the things we ask them when we're taking a plea. Can you read and write the English language? Every kid is going to say yes. If he's 15, he's been living in the United States for an extended period of time, he's going to say yes. What I think you need to do is ask the child to read something for you. Because many of my clients will say they can read and will read Jane, saw, spot. They're reading at 3rd grade levels or lower, 4th grade levels. Their ability to read is about forming the words and recognizing the words, but their reading comprehension, their fluency skills are very, very low. Now, I'm talking about from my personal experience. I'm going to give you some data in a few minutes. But these are children who, if they can't read in your office, may very well have learning disabilities that are either recognized or not recognized. If you have a client who has been recognized as having learning disabilities and has an IEP in his school system, you should consider applying to the court for release of those school records to you so that you can get the IEP and read it and share it with the court, because it may very well influence what should happen as a result of your client's case before the court.
Sue,
Yes.
tell us what an IEP is, because that comes up in forensic
I'm
interview.
sorry. I thought
Yeah.
I did that, Joe. I appreciate your saying that. IEP is individualized education plan. There is a requirement under the law in New Jersey that a child who qualifies for who has A disability that would qualify as a learning disability has to have an individualized education plan. Now, I mentioned earlier, learning disabilities in New Jersey do include ADHD and autism. But I look at the slide in front of you and you will see that what I think is most important for our clients with learning disabilities is that they commonly include executive function challenges or disabilities. Executive function, I'm going to talk about in a few minutes more, but what I wanted you to note particularly is that reading is a serious problem for a lot of the youth in our delinquency system. And there's not a whole lot of learning that's going on in detention. So if you have a child who is learning disabled because he or she has difficulties with any of these 8 categories, but in particular the reading categories, and that child is detained for 2 months or more pending a waiver, the setback educationally for that youth is greater than the impact of that kind of detention on a non-disabled child, because the non-disabled child and your client are going to be getting education within the facility. Most of that, much of it, especially during COVID, but even now it's a continued practice, and by my experience, much of what they're getting is by packets. They get packets and they're supposed to be learning from the packets, but in order to learn from the packets, they have to be able to read and they have to be able to engage in written expression. And our clients very often cannot effectively do that. So this reading is a big problem for us. And I wanted to make that point. If anybody has any comments they want to make about it, please jump in and talk. I really would appreciate hearing from some of you who are actually involved with youth, whether you have a challenge to anything I'm saying or some experience that may agree with it. Anybody want to comment? Okay, I'm going to move on then to talk about executive function. Executive function is sometimes included as being impacted by learning disabilities. Executive function is a set of thinking skills that include your working memory, your flexible thinking, and your self-control. Executive functions in childhood are challenging because although executive function skills begin to form right from the very first year of life, they're not fully developed until your adulthood. And that is why one of the mitigating factors that we now have in our criminal justice sentencing system is a mitigating factor that number 14, that the youth or the person before the court for sentencing, the adult, is under the age of 26. It's a mitigating factor because the brain has not fully developed until approximately that time, and executive function is the last vestige of development. Vestige is the wrong word. It's the last area of development. So your skills, your executive function skills are not fully developed until you're in your early adulthood. And executive function skills, did I write down here what they cover? Yes, I said working memory, flexible thinking, self-control. Self-control, these are the skills that allow you to plan. These are the skills that allow you to recognize the need for delayed gratification, to recognize the impulse control as an important factor in your life, to consider if what I do today will affect what a negative consequence for me tomorrow. Those are executive functions. Now, on the one hand, those skills don't fully develop until you're an adult. And we all know that from our own experience. Think about the kinds of decisions you were making when you were 15, 16, 17, and the kinds of decisions you make now. You're informed differently by your maturity to be able to have skill to delay gratification, for example. Now, these skills, these executive function skills, they are hindered. It is universal in the data. They are hindered by environmental factors, including ACEs. And Joe is sitting there saying, define ACEs. ACEs, adverse childhood experiences. Adverse childhood experiences, ACEs.
Yes, Sue, I wasn't going to say anything about ACEs, but you're right. And what I was going to say was about the executive functioning, the flexible thinking and self-control. You're absolutely right that that part of the brain does not fully develop. But what's fascinating, something else is happening. The back part of the brain, the hypothalamus, that is the emotional part of the brain, the one that gets a charge out of peers who agree with you or hanging out with the cool group, that part's fully developed. So you have this tension between what feels good emotionally and what makes sense emotionally. And the idea to join the crowd makes me feel good, and to be impacted by my peers' desires, that is fully developed and really functioning at a high level. And the front part, which tells you, well, might not be a good idea, is a laggard. Pretty interesting.
Agreed. It's a very important area. I think I'm going to give you some sites that will allow you to be able to explain some of it to a judge. But the best method of getting this explained to a judge when in a case that you are handling and where it's important and involves a potential impact on sentencing is to have a psychological evaluation by a doctor who understands and will explain ACEs to the judge. If you're doing a waiver hearing, such an evaluation would be essential.
Sue, I'm sure you'll address this, and I don't do this kind of work, but when I think about ACEs, which there's some fascinating research that led to that acronym, which I think was a weight study, an obesity study. But when we talk about adverse childhood experiences, and I suspect you're going to put this in context, it's one thing to say, well, they were abused as a child, or they didn't have a fair shake, or they're economically deprived, and people think you're presenting that as an excuse. But we also know that those experiences contribute, never mind that the brain normally doesn't develop properly, but that trauma impacts the brain. So you have a bit of a double whammy. These kids' brains aren't fully developed, plus they have trauma that interferes with the development and undermines their ability to make good decisions. And I hope I didn't jump your presentation, but I
That's all right. You can jump my presentation anytime. You are absolutely correct. The adverse childhood experiences compound the problem of children being different from adults. They compound it. Children are different from adults in their general development. And that has been recognized, by the way. I think I have this later in the presentation, but the case you want to look at for that, State versus Zuber. State versus, and I know I have the citation on here for you. We'll get to it. But State versus Zuber, Z-U-B-E-R, is a New Jersey Supreme Court sentencing case that deals with the United States Supreme Court opinions. There was a trilogy of them. They are Roper versus Simmons, Graham versus Florida, and most importantly, Miller versus Alabama. If you're going to be dealing with a case that involves important juvenile delinquency sentencing issues, you need to be familiar with that trilogy, and it will be explained to you, the whole trilogy will, in State versus Zuber. There's another New Jersey Supreme Court case called State versus Comer. Those cases are dealing with sentencing issues in New Jersey or juvenile delinquency, related to juvenile delinquency. And they are recognizing that, number one, children are different. Generally, children are different. But number two, in Miller versus Alabama, the United States Supreme Court said that not only are children generally different, but children who have that toxic stress in childhood, which was just referenced by Joe, children who have that difference compounded by the adverse childhood experiences they have. If you get you should know the Miller factors, because in Miller, the United States Supreme Court said, and here are some examples, here are some factors that would result in these, the adverse child, they relate to adverse childhood experiences, and these factors are the ones that will impact how, will relate to criminality in many respects with regard to children. So according to both Zuber and Comer, when you are considering, when a judge is considering sentencing of a youth, that would be someone under the age of 26. That judge is going to consider aggravating factors and mitigating factors. It is going to be your responsibility as the advocate for the child, to the youth, to point out that mitigating factor number 14, the mitigating factor that says that the child is, the defendant rather, was under the age of 26 at the time he committed the offense, is to be heavily weighted, more heavily weighted than some of the aggravating ones. I'll talk about that a little later, but heavily weighted because it has been created by the legislature on the one hand because of executive functions on executive function issues on the other hand. But in addition to that, the New Jersey Supreme Court has said sentencing judge also has to look at the factors of Miller versus Alabama. So those factors include, I'm pretty sure I have them in here. Joe did hijack me, but those factors are going to come up in a few minutes. We're going to talk about them more. And those factors include things like abuse and neglect. They are, let's see, it's a peer pressure, family and homes environments that are deficient. And the court has to look at those factors as well as the possibility of rehabilitation of a child. So when you're in a sentencing situation, you're going to be able to use your understanding of executive function and ACEs and Miller factors in order to argue the strength of mitigating factor 14 and the weakness of some of the aggravating factors, including, we'll talk about it again in a few minutes, but deterrence being among them, but we'll talk about that later. All right. Another important thing for you to understand about executive function is that executive dysfunction, statistically, there's a great deal of data about this, is a high risk factor for offending behavior. So you're going to be able to relate the ACEs and the dysfunction of your client to, or at least correlate it with the offending behavior. And then finally, you need to know that executive dysfunction can be improved in classroom techniques by educators. So if you've got a child who has experienced ACEs, and I had one the other day, a psychologist told me in the categories of ACEs, neglect, physical abuse, being in environments that had violence in the home or violence in the community, my client had 9 of the 9 factors. I believe there's 11. I'm sorry. Of the 11, he had 9. So the executive dysfunction that child had experienced was a high risk factor, made him high risk for offending, which could have been known when he was very young had he been evaluated properly. But that kind of executive dysfunction that he was experiencing can be improved in classroom techniques. It can be improved with the use of that IEP. If your client has one, that IEP can be vital to improving his dysfunction. Why is that important for you folks? because one of the things that the court is going to be talking about in sentencing, considering in sentencing, is the protection of the public. And, you know, I'm going to talk in a few minutes about the goals of sentencing. But one of the goals of sentencing is that protection of the public. I have a judge who tells me every time I'm in court, I'm not only concerned about the rehabilitation of this particular defendant, I have to be concerned about the protection of the public. Well, let's talk about protection of the public. If you've got a youth, a child, who has experienced such toxic stress in his youth that he is, as a teenager, deficient in has executive dysfunction, and that is relating to criminal behavior, you know from data that I'll tell you how to find at the end of this lecture, you know that executive dysfunction can be improved. There's data that's, and this data is from Harvard, by the way, it can be improved by the techniques that are used by educators in classrooms. That's why you have to argue to the court that this child needs to have education and classroom, a classroom IEP designed for him that allows him to improve his executive dysfunction, because that is the way to protect society, not only to rehabilitate the child, but to protect society. Because no matter how long this kid gets in jail, unless he's a life sentencer, and there are very few of them, he's going to get out. And when he gets out, we want to have that executive function problem resolved as best it can be, so that he not only is rehabilitated for his own benefit and his own enjoyment of life, but for the protection of society as well. So this piece, that executive dysfunction can be improved in classroom techniques by educators, is a very important piece for you. You will find it. I'm going to give you a Harvard citation later, but you will find it with very good authority. This is secondary authority, of course, but you're going to find it from Harvard. And you're going to be able then to link it to primary authority, that primary authority being Zuber and Comer, the New Jersey Supreme Court. Anybody have any questions about what I just said or comments on it?
Sue, I have a comment.
Okay.
That last bullet point suggests that classroom techniques can perhaps reduce the impact of executive dysfunction.
Yes.
And there are therapeutic and clinical ways to disrupt that dysfunction, if you will. And it's not just that bullet point there. The MRI over the past 15 years has demonstrated unequivocally, the science is inarguable, that you can reprogram the brain. In other words, these adverse child experiences, you know, I called it before the double whammy. You know, your brain takes a long time to develop when you're in your youth through natural child development and young person development, but also when you have these adverse child experiences, it disrupts not only the executive functioning, but parts of your brain. It kind of rewires the neurons, is a kind of crude way to put it, but you can put those neurons back in order through the right kind of interventions. There's no doubt about that. So this just isn't lofty progressive thinking. This is science, and there's plenty of research on this. But you need the right process. You need the right intervention. You need the right people. And there is hope for people who suffered these kind of youthful issues growing up. And you can support that by the science.
We agree.
So I have a question, David Pine. So
Yes.
we're talking about children, youth that are no longer in school. They may be out of school for 2 or 3 years. And then when you talk about youth that are 18 or more, there are less of those programs in place at sentencing than if they're a juvenile. So can you just talk about that?
I'm Mr. Pine, I'm sorry, I didn't understand what you said. You said that we're talking about youth who have been out of school?
Yeah, right. In other words, by the time we get the IEPs, the kids may have been out of school for 2 or 3 years. And now they're in the juvenile justice system or in the adult system. And the programs in the juvenile system are a lot different than the program. There are no programs for the young adults that are 18 or older. So the question I have is, if you want to argue against, the sentencing issues of protection of the public, how do you address that when these kids are not in school anymore and if they're over 18.
Well, okay, there's a lot in that, so let me unpack it a little bit.
Okay.
First of all, I'm dealing with youth who are 15 and even younger, 14 and 13, but children who have been involved with serious offenses. So you're talking about kids who are growing up in violent communities and are, let's take possession of guns, because possession of guns, possession of guns is going to get you enough points. Possession of a gun alone, going to get you enough points that if you have any prior record or if you did something with the gun, you're going to get detained. If you're 14 or over, you're going to get detained. If you're 15 or over, well, if you're 15, you're not only going to get detained, but you may very well have the prosecutor come in on day one and say, this crime that involved this gun was waiver eligible. So you're looking at the risk assessment that determines the intake on youth into detention. The risk assessment is based upon points. And those second degree crimes, especially if they involve firearms or other weapons, they're going to get you detained. So if you've got a 14 or 15-year-old who comes in to the system through that intake system, he's going to have enough points to get detained. So now you have a child who is sitting in detention. I don't know about your county, but in my county, you go 30 days to court appearances. It's 20 on the initial detention settings, but because you can make an application after 20 days to try to get him out. But they're going 30 days. So you're going to go before discovery is exchanged, before there's ability to really talk about resolving the case, you're going to go about 2 months. And so you're going to have a youth who's detained for about 2 months. Now, that person, that youth, may very well have learning disabilities that were recognized by his school system, and he may have an IEP, which is an individualized education plan. By taking him away from the school system and putting him in detention, you're taking away his ability to be educated in his IEP. So you're diminishing, if he has executive function skills problems, if he has ACEs, you're diminishing by the detention, you're diminishing his ability to be working on improving them. All right, so that's a first step. So children that we have that we're representing do sometimes have IEPs, and we can get them. And when we get them and we see that the child needs a particular type of education, then we want to argue that he should be released from detention, put on an ankle monitor if that's what's necessary, but get back into his classroom as soon as possible, because otherwise he's losing not only the ability to work with his executive function here, but he's losing his IEP education. If you're in court on a serious case, with or without waiver, while you're detained, you're going to go about 6 months before you can actually resolve that case. If you've got a kid sitting in detention who has an IEP and special education, he's sitting in detention for 6 months. That kid loses that school year. He falls behind, and it may be impossible for him to recover that. So that kind of an argument you need to use to get your kids released from detention. So that's a first step. Then as we go on and advance it, you have some kids who have not been identified as having IEPs. But as I said, when you sit down with him, you ask him to read, he can't read. That means that there may very well have been some failure in the school system to get him into the special education system when maybe he needed it. Now, one of the things that I personally have experienced is that, and others may have other experiences they want to talk about, but what I've experienced is that sometimes the school has recorded in their records behavioral problems with a particular youth, and a recommendation to the parent that the parent have the child evaluated for special education. Some of the parents don't follow through. Well, neither does the school. So the notice to the parent resulted in the school taking no further action. Parent doesn't follow up. When the kid gets really bad in class, they move him, the school can move him out of mainstreaming and into the special schools because of emotional instability or something like that. So they can move him out. Or with some of our older kids, they can, after 16, push them out completely. But you essentially have children who, if they're not evaluated properly, are losing the ability to be educated and to reduce the executive function. And you pick them up. You can pick them up from their school records and their behavioral history when they're 15, 16, 17. And that information that you're picking up, you can, and child protection records as well. But from the information you're picking up, you can then try to convince the prosecutor not to waive. You can share the information with your psychological evaluator for the waiver. And then once you've had the doctor review all this and support you in the idea that this is a young man who needed special education, now you go to the judge and you say not that he is a special ed student, but he needed it and he didn't get it. And at this point, he's not educated enough to have, for the state of New Jersey to have met its thorough and efficient education requirements, because he's not effectively able to read, and maybe he's reading at a third grade level when they've pushed him through and he's now in 9th grade. So you're going to find that with your students, especially the ones who have genuine learning disabilities. If they have an ADHD is, Joe, help me out with this. Hyperactivity disorder. It's attention deficit hyperactivity disorder.
Natalie Wood.
You'll find a lot of that with the youth who had toxic stress environments when they were growing up. So you're going to find these learning disabilities if you look for them. They may exist already and been identified, or you may find them. Now, that's for the kids who are still in the juvenile system, and they are still in school. So, and those kids, if they're going to go into Jamesburg, are going to get evaluated for not for learning disabilities. They're going to get evaluated for special education. Their education needs will be evaluated when they get into the Juvenile Justice Commission's custody. And when they're evaluated, they're going to be found to belong somewhere in a program. Now, sometimes, and your CMO, case management organization, and your Juvenile Justice Commission are sensitive to this. You have to be very careful about this. Some of these programs are dependent for their funding on their outcomes. So if you've got a child who is not likely to be able to effectively participate successfully in the program, they may reject them. Not because, Joe, you want to come in on this? I see you lighting up there. You want to come in, Joe?
No, I was just clearing my throat. I had my mic on. Go ahead.
Oh, I'm sorry. Okay. So you need to be thoroughly informed about your own client's educational history. And when you are, especially if you're dealing with a case that involves waiver, when you get to the adult court for the judge to be evaluating aggravating and mitigating factors, that mitigating factor of being under the age of 25 is the one that you want to be able to make a compelling case about. Now, you also said something about there not being programs once they're adults. That I want to push back on you a little bit about, because there's two different forms of waiver in New Jersey. There's involuntary waiver and there's voluntary waiver. The involuntary waiver statute provides that if a child is under the is involuntarily waived to the adult court, he or she has a presumption to remain in the Juvenile Justice Commission's custody until he or she attains the age of 21. The administrative code in New Jersey provides that if a youth has remained in the Juvenile Justice Commission's custody until they were 21, then they can apply before they turn 21 or at 21 to remain until they're 25. By agreement of both, so that the commission and the youth would have to agree that he was going to stay until he was 25. And the limitation upon that would be that he'd have to max out before he turned 20, within 2 years. So before he turned 27. So you may very well have offenders, youthful offenders, who remain in the custody of the Juvenile Justice Commission until they're 27. Now, there's not a whole lot of them, but 23-year-olds, 24-year-olds, yeah. And they are in a position when they're in the Juvenile Justice Commission's custody to enjoy all the programs that are available in that through the commission. So they do have the opportunity for education, even if they're waived. But in order to get it, you as defense counsel have to make sure that whatever you're negotiating with the prosecutor includes a provision today. Now, they're working on changing the law to make a voluntary and an involuntary the same. And there's actually a memo that's been put out that is being used in some counties where the prosecutor will agree that it's a voluntary waiver, but all the provisions that would have been existed with that presumption can apply to your client. Now, I don't like that. What I do when I plead a guy is when an involuntary waiver has been filed and we negotiate a plea, the plea, if not to juvenile time, but to adult time, that plea is going to be going in as a consent to an involuntary waiver. So that, and it's very clear, it's put it in the order, that the provisions of the involuntary order waiver statute apply so that he can remain in the custody of the division, the Juvenile Justice Commission, until he attains the age of 21. Now that, there's an exception there. The division, the commission rather, can throw him out. So you're telling your client, what you have here is an opportunity, but it's up to you. If you violate the rules, you fight with people in the facility, you carry on with other criminal behavior, they can throw you out. But if you don't, you can stay. And they may be willing to allow you to stay until you're 25. Now, what I try to do is negotiate a sentence, even with no early release act time, even with Graves Act time, negotiate a sentence that the youth will be able to serve in the Juvenile Justice Commission's custody. That way, what we have done is provide the child with an opportunity. And I think that's probably the best thing that you can do as a defense attorney in the juvenile system. You get them an opportunity so that the wrongs that they engaged in when they were 15, 16 years old don't define the rest of their lives. And that's did I answer your question?
You did.
Well
Check.
put, Sue. Sue, you have 25 minutes or so, FYI.
Oh, all right. Well, thank you for everybody jumping in, because that does help to move the time. All right. Justice involved youth. Here's some more data for you. 65 to 70% of the juvenile justice involved youth have intellectual or developmental disabilities. That really shouldn't come as a shock to you. At the end of this slide presentation, which I think you have a copy of, or will get, there's the citation for this. It is an article that I cited to you, and what I am suggesting to you is that you take a look at that article, not because it's the best article in town, but because it has a great glossary and what you're going to, and bibliography. So what you're going to do when you look at this article is go and look at the footnotes, and there you're going to get your original sources. So when you go to the judge, you're going to the judge with original sources. You can get them in the article, and then you can update them through your own research. But this is a case finder, essentially, this article. The data says 65 to 70% of juvenile justice involved youth have intellectual or developmental disabilities. There is also, I just found yesterday, a New Jersey Bar Association journal that it's called the New Jersey Lawyer. Everybody probably knows that. If you have a subscription, you can access the New Jersey, if you have a subscription to the journal, I believe you can access the New Jersey Lawyer at the website. You can access it online. But in number 335, New Jersey Lawyer, the April 2022 edition, children with educational disabilities is the topic of the entire journal. And there's an article there called Juvenile Justice Involved Youth May Be Denied Freedom, but Not Faith, what I was talking with you before about. And it talks here about how defense attorneys can work with the learning disabilities of the youth who's involved in the juvenile justice system. You can use it for some of the things I already mentioned to you, and there's a good deal of information here. But in addition to that, there are endnotes, and the endnotes again provide you with New Jersey sources, both statutory and primary sources about children with disabilities in the system, in the New Jersey system. Another piece that this article talks about that's at the end of your this lecture here is that a young person once engaged in the juvenile justice system is likely to stay engaged. If you get put on probation, the potential to violate, especially a child who is disabled, potential to violate probation is extremely, well, I shouldn't say extremely high, but it exists. It exists in large portion. Recidivism rates for youth who are placed on probation, it's state data shows that youth rearrest within 1 year is 55% on average. If there is DCPP involvement with your client, this is a child who is involved with the Division of Child Protection and Permanency, that is our child welfare system in New Jersey. Involvement with that child welfare system is highly correlated with potential justice involvement, juvenile justice involvement. The children who are involved with abuse and neglect, which are the cases, and abandonment, which are the types of cases that are going to be taken by DCPP, are children who tend to have trauma and other damaging or unresolved experiences, your ACEs, your adverse childhood experiences. And they put young people at risk for juvenile justice involvement. Doctors, again, from Harvard tell us that delinquent behavior may be manifestations of trauma, trauma responses, or defense mechanisms to the unsafe environment that the children grew up in. And if you want to learn more about adverse childhood experiences, here's where you want to go. This is the CDC, that's the United States federal government agency. It's about ACEs. It's described there, okay? Now let's talk a moment about disproportionality. You may have to convince a judge that there's some kind of disproportionality. I don't have primary sources on that at this point, but we have secondary sources. And again, you can spring from some of these articles into primary sources. Black and Latinx boys with disabilities made up 3% of the enrollment in schools, but they made up 12% of student arrests through the schools. This is through the schools. This is an education department statistic. 3% of the enrollment, 12% of the arrests from schools. Black youth make up 15% of the children over 10, but 35% of the cases handled by the juvenile court. Now that's not only disproportionality, mind you, that's substantial disproportionality. If you had Black youth making up 15% of the children over 10, and you had 16 or 17% being cases handled by the juvenile court, you'd have disproportionality. 35%, you've got extreme, substantial, I should say, disproportionality. When you add in the Latinx and other youth of color, they make up over 50% of the cases handled by the juvenile court and well under that percentage in the population of, now this, I'm not talking about school population here, I'm talking about population overall in the United States. I mentioned detention earlier to you. So that's just a statistic about how many youth are in detention in 2021. I don't have anything better than that, but OJJDP is the Office of Juvenile Justice and Delinquency Prevention. That is a national office. Length of stay in detention facilities is 27 days on average. And the reason I put this in here is, in particular, I talked earlier about the youth who's going to be the subject of waiver and how long that youth is likely to be in detention. But even if you have a car burglar who ends up in detention, you've got a 27-day stay. If you've got a child who's got learning disabilities and you lock him up and he's not getting his IEP education, his intensive, his individual education attention for that 27 days, he gets a setback, which may or may not be recoverable. So detention, especially for children who are not going to get prison sentences, jail sentences, detention should be no more than a few days. You've got to move to get these kids out. You're entitled to move every 20 days. And you ought to be moving every 20 days if you've got a kid in detention, try to get him out of there, because the loss of education is decimating for the lives of some of these kids. Yeah, there, I wrote it there. What is a 27-day absence from T&E due? That's thorough and efficient education, due to the educational prospects of a youth who's learning disabled. Not just his current learning, but what does it do to his learning prospects if he misses that much time? Now, some people may be sitting there saying, well, our clients are missing school anyway. They're not going to school. And even if they're learning disabled, they're not getting their education. It's not detention that's keeping them out. It's just the way they live their lives. Well, that may be. That's a different kind of problem. I'm talking about what we're dealing with in the delinquency system. Now, services within the juvenile justice system. Once a youth with disabilities enters the system, they're given few, if any, resources to improve their future well-being. I talked to you about packets a few minutes ago. That's packet business. That's where the kids get paper that they have to read and they have to write the assignments out. That kind of packet education began during COVID because nobody was going into classrooms. So that it began then, as far as I know. But it is continuing to the present day with my clients. Now, I have a lot of kids who are detained both in Atlantic County and around the state. And they are, the theory that the Department of Corrections is using for their education is that they're going to get packets. My clients, for the most part, most of them cannot read well enough to be able to get educated from a packet. And I have experts, when I deal with waiver cases, I have experts who will stand behind me on that. You don't only have to have experts in waiver cases, though. If you have a child that you're working with and he or she has some CMO, case management organization services, that child may very well also have a psychological evaluation that says what kind of educational opportunities he has or needs, what kind of educational needs he has. So it's not just the most serious cases to which this concept is going to apply. Incarceration for any amount of time can have a negative impact on the youth because it disrupts the education, especially the disabled. Okay. Well, the juvenile justice system is supposed to be rehabilitative, and I just offer you this question. Does that look rehabilitative to you? So what can attorneys do? How many more minutes do I have, Joe?
You have about 12 minutes.
Okay, prepare. In order to prepare, in all formal or serious juvenile delinquency cases, obtain a court order for release of the education records, including special ed and IEP. As soon as you go into court, especially if a child is detained, apply for their education records. you're going to find a tremendous amount of information about the child in those records. And you can ask the parent, if the child has a DCPP history, a child welfare history, if the parent has that, you're going to ask for those records too. Now, I have had parents who told me that they want to fire me and get a new lawyer because I've asked for their DCPP records. And I invite them to go ahead and find the attorney who in whom they and their child will have confidence because they're entitled to that. But I get the DCPP records on all children to the extent that they exist. All prior psychological evaluations. Some of your kids have gotten them through schools. Some of them have gotten them through CMOs. Some of them have gotten them because the parents or grandparents have sought them out. You want to get all psychological evaluations on your clients. And especially in waiver cases, always, if you don't have a psychological evaluation, or if you do and it's more than a year old, you must get a psychological evaluation, because in waiver cases, there are 12 factors that the prosecutor has to consider in determining whether or not to waive. One of those factors involves the behavioral health and substance abuse history and status of the child. And I believe if you do not get a psychological evaluation that is current, that it would be grounds for a PCR later if the child was waived and on grounds of inadequate assistance of counsel. Psychological evaluations are good for a year. If you don't have one that you can argue from, you absolutely must get one in order to work your waiver case properly. You need to get it not only for the waiver hearing, but you need to get it for that sentencing hearing, because one of the things you're going to try to argue.
Natalie Wood.
Oh, if it's a minor matter, you want it to go to an informal calendar. Even if it's snuck its way onto the formal list, offer to stand down and ask the prosecutor to stand down and push that thing back to the informal calendar when you have no prior record on a kid and the kid is charged with offenses that are likely to result in minor remedies, probation, that sort of thing. Get them informal as often as you can, as much as you can. Move quickly and often, every 21 days for release from detention. Every 21 days if you have to, because the longer the kid's in detention, the further back he falls. Avoid Jamesburg deals to the greatest extent possible. So if you can get the kid into a program that's run through the JJC, a residential treatment program, or if you can get him into the Juvenile Justice Commission programs that are residential, do that. You want to avoid getting him behind the walls at Jamesburg, because even if they have good programs there, my judge says, oh, Jamesburg has the very best programs for kids. Maybe it does, but the population is difficult for the children to navigate, and especially your children who have learning disabilities. They will tend to be so influenced by the peer group that anything that they get during the day in their program will be lost in the interaction they have with population. Avoiding Jamesburg deals to the greatest extent possible is what I suggest. When you cannot avoid a Jamesburg deal, when waiver is likely, you want to try to structure an agreement to keep the youth in Jamesburg for as long as possible. That's what I mentioned to you earlier. And if anybody has any questions about that, I certainly would like to take them. You want to consider plea provisions such as, you want to consent to an involuntary waiver, as I mentioned earlier. You want to structure the agreement so that the youth can remain in the JJC for his full sentence if it's possible. So you want a sentence under 20 that'll get him out before he's 27. You want a presumption that the youth can remain in Jamesburg until he attains the age of 21. I put all of that in the plea agreement. And this is the administrative code provision I mentioned to you earlier. Secure the prosecutor's agreement to send the psychological evaluation that you have obtained, your psychological evaluation, which has recommendations in it, have that sent with the PSI, with the child, to Jamesburg, or whatever facility he's going to be in. And then you want to use very strong emphasis on mitigating factor 14. There's State versus Zuber, 227 New Jersey, 422. And the Miller factors. Miller is Miller versus Alabama, 567 US, 460. It's a 2012 case. Before I go into new developments in the law, I want to go to the previous slide, and I want to say to you, by way of your plea provisions, what you're aiming at is the ability that you will have, and always, I didn't write it down here, but always in your plea agreement, if it's possible. Somebody told me you can't do this in some counties, but in my county you can, and I do it all the time. I say, okay, the prosecutor's going to recommend, the other one I had a couple days ago, the prosecutor was going to recommend 11 as an adult sentence and 11 on a first degree. He insisted upon first degree plea, So I went to the court with a plea agreement that said the prosecutor enters this agreement understanding that the defense will argue for less. Now, the statute says you can always argue for less. But sometimes when you make a plea agreement, the judge thinks you're agreeing to what the prosecutor is recommending. So I will specifically say in the plea agreement that the defense will argue for less. And then I'm going to use the psychological evaluation, the Miller factors, mitigating factor 21, and the learning disability information to argue for a sentence that will be low enough. I try to keep it under 25. I try to keep it under 21 if I can, but low enough so that this child can get the benefit of the educational opportunities that are available through the Juvenile Justice Commission and would not be available if he were transferred into an adult population. So I have a prosecutor who will periodically work with me on that. He demanded an 11 last time. I argued for an 8. I asked the judge to find mitigating factor 14 as well as that to minimize the concept of deterrence, because you will find a great deal of data, and I'm not going to go into it here, I don't have time, but you're going to find a great deal of data that children under the age of 18 are not deterred. They are not deterred by imprisonment. And the recidivist rates reflect that youth who get programming do far better than youth who are imprisoned as far as not reoffending. So you are in a position to get that data and argue to the court. Deterrence should not, because for individual deterrence, should not get a strong weight here. It is outweighed by the mitigating factor 14. That's what you want to try to argue against the mitigating factor, the aggravating factors and strength on that mitigating factor. One of the aggravating factors the court commonly relies upon is the character and attitude of the defendant. You're going to be in a position to argue that the evidence that the court has before it based on the behavior of the defendant is behavioral. It's not characterological. And then you have to point to all the goodness that you can find in this child's behaviors in the past and in his soul that are going to show that it's not his character that is the problem here. It is behavior that was influenced by the negative environment in which he grew up. That's the way I try to get the judge to balance aggravating and mitigating factors. I have had some success. In the case I just talked about where the prosecutor wanted 11, I asked for 8. The judge said, I can't. I asked him to find in my, file a sentencing memo, by the way. I asked him to find that the interest of justice required sentencing a degree lower. And because in that case, there were 4 different victims. He was unwilling to find, he said he could not find that the interest of justice required it to go a degree lower. So he gave him a 10 instead of 11, but he did cut it back a little bit. Which means he read my papers. So they're going to read them. Well, he's my judge. He reads them. When you write them, he reads them. And he did take what I said into consideration. In that particular case, there wasn't really from the beginning, probably too much hope for the kid. There were 4 separate victims there in a violent crime. But a last case to mention to you is for your concurrency, and your consecutive sentencing, the State versus Yarbo is the watershed case, Yarbo. That's a New Jersey Supreme Court opinion. But since then, State versus Torres, you can, I think I have the sites in here, but if I don't, you can dig them up. Yarbo and Torres. Torres says, well, first of all, Yarbo said that you look at the circumstances of the crime, but if you have more than one victim, consecutive sentencing may be appropriate. What Torres says is you look at all the circumstances. You are not constrained by Yarbo to give consecutive sentencings for more than one victim. So even if you have more than one victim, as I did in this past case, you can still argue for concurrent sentences based upon the circumstances of the case. And that's again where you're going to hit that mitigating factor and the Miller factors to try to argue to the judge that the circumstances of this particular case do not require consecutive sentencing, even though there's more than one victim. Okay, Joe, am I done? No, you're Joe.
Yeah, no, I got it. We have to give the secret code, and we're gonna wrap up. Yes, stand by.
Get this code to get my credits.
Lever.
The code is DIE 18. And it's also,
Karen, can you pull that down a little bit?
yep,
Die
in the group
18.
chat.
Gotcha. Okay,
Yep.
thank you.
thanks.
So that's DIE, just like the credits you're achieving today: diversity, inclusion, and elimination of bias.
Joe, just one thing before you wrap up. There's a new burglary law. Everybody should be aware of it. If you're not aware of it, take a look at it. It's burglary, it's home invasion, and it's going to impact sentencing for juveniles.
And Sue, I'll make sure everyone who is participating today will have a copy of your program, your
Thank you.
presentation. Thanks.
Yes. So in closing, this is the last presentation for the year. We have the holidays fast approaching. We had a great time about 2 weeks ago or a week and a half ago at the holiday beefsteak. What we also have, and I want to share with you, there may not be any programs coming up, but not everybody had attended or participated in the 4 programs that we had beginning in November. So we've made them available on our YouTube channel, and you're going to be getting an email from Karen either later today or tomorrow morning, which has the links to the YouTube channel. Now, we have followers already on the YouTube channel. If you go there now, you'll see our programs that have been uploaded for the past couple of years. I would remind you, though, that any program that we put up that's more than 2 years old, you can't get credit for, according to the Supreme Court, which makes a lot of sense. The other thing is the rules were changed since COVID. And I looked it up, Karen, at least 50% of your credits have to be live or on Zoom in real time. This would be considered the equivalent of live or in person. This is a real-time program. It is the equivalent of going to some hotel or to some space and getting CLE training. What is limited are the asynchronous programs, or what we call on demand, where you can go online and click on something that happened in the past. That's what our YouTube channel is. So for your 2-year credit reporting period, you can get no more than half your credits, 50% of your credits from on demand, or from what we call asynchronous. Or to state it differently, half your credits have to come live or on Zoom in real time. So something to think about. And we have for you on our YouTube channel. And if you go there, just click that little button that says follow, and then you'll get updates and premieres and all that kind of stuff. We just uploaded Professionalism Day. That was delivered in November, and that was really good. We got a lot of participants, in part because it was free, but I'll tell you why, because we had a justice of the New Jersey Supreme Court. Justice Noriega was there, and he did a wonderful job about mental health. It's an ethics program, so you can get those ethics credits, okay? There's also a program I did called Algorithms and Advocacy, Navigating AI Ethics in the Legal World. Some more ethics credits that you can get on demand on our YouTube channel, and that was a few weeks ago. I also did something with Sue and my old friend, Dr. Jason Dickinson from Montclair State University, where we did a program called Memory on Trial, where we looked at memory error and the things that impact human recollection within the legal system, whether it be civil court or criminal court, but there was a focus on out-of-court identifications. And lastly, I'll tell you, I think it was last week, we did a program on the new drunk driving rules and plea bargaining. It was called, I Wasn't Drunk, I Was Only Reckless. Warren Sutnick, I mean, this guy's the best. I'll tell you, what a great program we did on drunk driving. Some of my colleagues who are accomplished DUI, DWI defense lawyers learned a few things in that program as well. And in that program, we had a guy who owns a company that installs those interlock devices. He had about 20 minutes to talk. There's a transcript on our YouTube site, or at least there will be, where you can follow along, or you can look at the end there, where that man, Jason describes, if you have a client, that you need to put that interlock device on their car, exactly how to do it. But another great program. They'll all be available. Until next year, where we hope to have some really cool programs as well. I'd like to say happy holidays. Karen, anything you want to share with us? Sue, on the way out?
I just want to say thank you to Sue and Joe. Thank you so much. I also want to say that Judge De La Carrera's retirement dinner is coming up in January 16th. So, and it's filling up quick. So I would recommend, if you do want to attend, please get your forms in as soon as possible. But thank you, Sue, and thanks, Joe. And Merry Christmas and Happy New Year, everybody.